Abum ana esibo so in Ken Ofori-Atta matter no within the week na me catch them say there's a major update in Ken Ofori-Atta case no inti mayamamo inti no man na mo expect na ache no mesremo forgive me. It's a 95-page ruling. 95 pages there. I can't just brush through and come and conjecture. I had to read everything. Inti acha, I apologize for that. And then my video on Ken Ofori-Atta and appear could be making some serious allegations on my TV3 media me say these things are unnecessary. Omo cause won't me lot of pain. I'll bring that to you. But you can't Ken Ofori-Atta. Ninti OSP adwa, ninti Ghana for be adwa say ah. Enti mo do ba butrika pom nam de akoma mo nansia butrika ko conspirator. Bese court see emfanenko. Ana mote wona Ken Ofori-Atta ye kroko de bi say ah OSP ye kan ye wabon nen document no de court na nya papa. Enzem bebre then the 94 pages. You be as analysis no e the amount bo ho the video no wo be hwe akosi eche. There's a lot of education, there's a lot of information, and I'm using court document. This is not the opinion of Eugene Osei-Tutu. This is the opinion of the court in the United States of America, and that's exactly what you'll be doing in this video. What is the latest? And I'm the bro. Make sure so be subscribe and subscribe and click the notification. The video be tomorrow. You have a comment, feel free. Leave that comment in the comments. Should we have Goldberry Construction Limited? Don't die episode sino. Wasas and krata some the documentations related to your house in Goldberry in the bidi jumanama. And I'm still reminding you, says, you're a flat victim. Now we hear a certain renovation works at your facility. I'm sure for Goldberry. Baby, this age money now at the amor bring pomba. So addition related to trauma related to jet care or bring pomba or a show. Nebi bia I kama at the amount. Now let's go into the matter. Once Ken Ofori-Atta leaving the country around the 4th of January 2025, what we are told is that the former chief of staff, Madame Fremont Pare, the incoming chief of staff, Yera Julius Debra, and the transition team were notified. They gave him permission to travel. Now, subsequently, he was supposed to come to the country on February 28th. Wama. And I always feel better about things. So charges be or certain answers to answer. Can say, "Oh my, I call you operation. We have time to recuperate into your obey Zoom be issue." The professor, I think, Professor Angela Ofori-Atta something about joy. And the boy say, "I need kuni baba. And then why not? On one best submitting kuni. Only be to hide in there." Subsequently, born no ma. On the 6th of January 2026, and yet chain. Ya chain woni fie eyes any ade because one overstay in vessel no any ade the co-detention center ye omo ye no investigation ni bibia amobia hwe bia wo na me use to make answer me dey try and absence and start ko papa no no chebi ata say wo ma na say better say we apply for permanent residency and na ye clear. And when I read for you, you know the reasons why. And okay ade education, you know, I don't know whether I took note of the comment. Obi my comment to say under Donald Trump, so always certain amount to be they can give you permanency of stay in the US. I decided to read on it, so it's a lot of information. But before my opinion, let's go to the court. Forgive me, I have a bad nose. Now you can see, say the court, Mr. Anderson in the Mama Ghana, and an lawyer no Kwansima and agent medicine mechanics and mathematics mechanic Kwansima and agent Ken Ofori-Atta. Omuna bon common from the 80 pages my background na there. But the ruling of the court is what's most important, because we know certainly what Ken Ofori-Atta lawyers to say: abuse of human rights, he is being persecuted, he has a health issue. That's actually the issues they raise. His son is a citizen of the US, he has strong ties to the US, he has business portfolios in the US, he has money, he contributes to his community regularly. All these are in the judgment. And Anderson said there be what's from Ghana for. From Ghana, that's what answer question. So whether there's even a criminal offense against you or not, even when there's just an inquiry needing your service, you must be present to answer. And a court neighbor kasawaha. Now, on my English, na style be kakra. You know, let's be patient with me as I read for you what the judge said. Now, you're starting free or say. The respondent is a 66-year-old native and citizen of Ghana. January 6, 2026, notice to appear was filed at the immigration court on January 7, 2026. The record shows a notice to appeal served personally on the respondent on January 6, 2026. At a hearing on November 20, 2026, the respondent admitted the allegations concealed considered irremovability, and the court sustained the charges in the notice of appeal. Once I want to know a D in immigration status, not to someone called Virginia Detention Facility. No. Okay. Now, of course, the court directed Ghana as a country of removal. The issue before the court today concerns the respondent's application for release from removal. It's the court in the reason why you're matching in there, how the ruling will ban a immigration issue. But or say the respondent has applied for asylum, withholding of removal, and for protection under the Convention Against Torture. It's here Ken Ofori-Atta will apply for asylum, withholding of removal, and for the protection under the Convention Against Torture. Or say, and the respondent has applied for an A48 application for the adjustment of status based on his United States citizen Sans 130. 130, I'm told, is the petition for alien relative. It's Ken Ofori-Atta ba a US citizen. To no file for mama ne papa so ne papa base my citizen. Kona ya ne ba. Yeti na man for mo mbako wo ho no. Tisa process no so another process wa file for. The court has found that it will grant the application for the adjustment of status as a result and will not address the 1589 application at that time. Separating the statement of law and addendum additions, stating the standard of law relevant to these issues will be served on the parties and a copy placed on the record of proceedings. That additional addendum is hereby incorporated into this decision by reference. Separating summary of the respondent and Dr. Brumond. Dr. Brumond, the full name Dr. Theodore Brumond, or an expert when it comes to immigration issues. Say, you be see you will be free US. Will be see a teacher and a fan who deals when it comes to ISS. I didn't say Interpol near mano. Yes, you should be a knack or two red notices near mano or your expert. Your friend Theodore Brumond. Or say there is no dispute concerning the credibility of the testimony by either witness. Or say what Ken Ofori-Atta or no respondent. No tell Dr. Brumond that. Tell me man be kind is solid. DHS, Department of Homeland Security, did not argue that either witnesses did not testify credibly. The court found that the testimony was consistent with the submitted declarations and consistent with other evidences and internally consistent. The court found that both witnesses were candid and responsive, and nothing in their demeanor suggested an attempt to mislead the court. And therefore, the court found that the respondent and Dr. Brumond credible as their subjective fears and concerns and opinions. Separating adjustment of status and the respondent United States citizens brought an I-130 application on response on behalf of the respondent. This was brought by the USCIS. So I'm told is the United States Citizen and Immigration Service. DHS has agreed that the respondent is eligible for the status, for the adjustment of status, except for an issue of discretion. I'm saying, Ken Ofori-Atta there, you share the documents to be BM or you're eligible to see about adjusting the status among the permanent stay. The only thing is discretion, a discretion of the judge. And of course, the court must exercise its discretion in determining whether to grant the application for the adjustment of status. This is the only thing at issue. To say, Ken Ofori-Atta who near some from some affair, nearby US in assembly, including evidence on who Ken Ofori-Atta na aka. Say, ade Ghana for na shada person sa. Dr. Theodore Brumond so yet Interpol expert so aka. The testimony no DHS, Department of Homeland Security, credible. It is judge and our court me metie de. What tie ni nyina Ken Ofori-Atta bobi ani no. Ade say judge na me metie asem so na me decide. And also a matter of discretion. But what I say. Now, an immigration court must consider the totality of the circumstances, weighing all positive and negative factors. The respondent bears the burden of proving that there are positive equities, such as family ties, length of residency, community contributions, outweigh any negative factors like immigration violations or criminal history. It was say, the basic determinant to grant someone or change the person's status: family ties, length of residency in the country, community contributions, and that will outweigh negative like immigration violations. Our turnover state is a Ken Ofori-Atta there, and also criminal history. There's the court speaking. Now the court goes further to say that the court has reviewed the respondent's background. He has many positive aspects to his background. He attended school in the US. both undergraduate and both undergraduate and graduate school. He worked at American firms including Morgan and Stanley, the Salomon Brothers. The court believed the respondent has significant financial resources. They make one for that. They can refer to whisker before MPP before whisker. And my catcher will say, "Would you bet me we do on it later?" Let me just go on. We'll say he has served as the Minister of Finance and was deeply involved in business in West Africa. Served as Minister of Finance for 7 years for the government of Ghana from 2017 through 2024. Then served as a high-level government advisor to the President of Ghana until he left office in December of 2024. The respondent founded an investment bank in Ghana, was involved in the creation of a large insurance company in West Africa. The respondent's son is a United States citizen. The respondent has no criminal history whatsoever in the United States. The respondent has been present in the United States undergoing health treatment for cancer and other conditions. Or say, Ghana Krawa Service Finance Minister or some service advisor will be investment bank or Ghana will be insurance company in West Africa. They buy a US in it. Money be in only criminal record. Bia ewo baby. Court no court kase. The respondent attends church services regularly. Of course, sorry the bia. He's been engaged in charitable causes, both on personal level and also through his financial and other public support. The respondent has engaged in significant public service. 2, as a public official in Ghana working without a salary, as a government official for a lengthy period of time. Say, oh, can you refer to our son or some Ghana crana when you pay or co-officer when you pay Biscabian who can tank a card court can you America court. Okay. The court goes further to say that the court also concerns negative factors, including the fact that the respondent overstayed his visa before being sought for prosecution by the government of Ghana. But the respondent overstaying his visa after his US citizen son has filed an I-30 petition on his behalf. The court found that the respondent was pursuing in good faith to legitimate his status in the United States while overstaying the visa. Say, oh, I'm passing the visa. No, but so the basata and the filing a mechano petition for alien relative na edi amano. It is also overstay no can a good grounds. That will change America emra for beka abasa application and the ba US citizen na file the amano. Or say, in consideration, while the circumstances, including his need for medical treatment and the circumstances of the action of the government of Ghana, the court finds that the respondent's immigration violation by overstaying a visa was relatively minor. And yet, dear, you better withdraw on it, Debbie, court say. Or say, the larger question for the court is whether the respondent has been credibly charged or engaged in criminal wrongdoing in connection with his work as the Minister of Finance of Ghana. Tahana oba Ghana dem. Ahana OSP dry no. Titieni. Or say, the court finds that the respondent has established that he did not engage in wrongdoing, criminal or otherwise, as Minister of Finance or as a government official in Ghana. The court also considers Exhibit 5, which is an over 200-page affidavit from the Office of Special Prosecutor in Ghana, which described the claimed illegal criminal wrongdoing by the respondent to the Minister of Ghana. Also, the court has examined Exhibit 6, which are the criminal charges pending against the respondent brought by the Office of Special Prosecutor, where the respondent is charged with over 70 counts of criminal wrongdoing in Ghana. The count would note that it has great experience in reviewing and considering allegations of corruption among government officials, fraud and embezzlement, and similar wrongdoing. The court has considered the opinion of the respondent's attorney, who is a lawyer in Ghana, a former law enforcement official, concerning the criminal laws in the country of Ghana and the background of the charges in the Office of Special Prosecutor. The court carefully reviewed the Office of Special Prosecutor's affidavit, and the court finds that the affidavit is lacking in any persuasive proof or evidence that the respondent engaged in any or has engaged in any criminal wrongdoing as alleged as Minister of Finance or as otherwise, or that the respondent personally profited from his work as a government official in Ghana. Or say, 200 pages of Office of Special Prosecutor document to bet you on court and say, oh, what person man the permanent residency? Papa, or debes was organ to Monchas ideas because oh, shame, it's a Ken Ofori-Atta lawyer. Or no so Ghana no on the charges and nyansasem bi eni sa de evidence bi eni manya persuasive just ade between a convincing judge and some paka na ye boni bi ese de ne ba Ghana oso otie mu no sebe emu ha nyansasem bi eni sa de eni nyina so papa bia enim court na ekase o say The lack of persuasive evidence indicating any kind of criminal wrongdoing or criminal conspiracy involving the respondent in the OSP's affidavit is powerful evidence. The respondent has not been credibly charged or credibly has been shown to engage in any wrongdoing in Ghana. Tomo say, send ye kase OSP and charge Ken Ofori-Atta. Again, document on the buy no ohema nyansase bi enim emu ha. We call to ne kase. Now, a buyer na OSP so they let a buy. Or say, the Office of the Special Prosecutor has taken note of a transcript of hearing purported emanating from the immigration court in the US involving Mr. Ken Ofori-Atta, which is being circulated by some media houses, suggesting that Mr. Ofori-Atta has not been credibly charged in Ghana or credibly shown to have engaged in any wrongdoing. The OSP stated that on the 16th of June 2026 that it is not involved in the immigration hearings in the US involving Mr. Ofori-Atta and the OSP's involvement relative to the extradition process against Mr. Ofori-Atta through the Attorney General as the central authority. The OSP reiterated that the extradition packet is not before the immigration judge. The credibility or otherwise of the criminal charges against Mr. Ofori-Atta is a matter of determination by the court in Ghana, which has the jurisdiction to determine his guilt or innocence. Such matters are not determined by the immigration court in the US. The OSP stated that it is important to distinguish between three separate legal proceedings against Mr. Ofori-Atta: US immigration proceeding concerning the immigration status in the US, extradition proceeding in the US, which will determine whether Mr. Ofori-Atta should be surrendered to Ghana under the relevant extradition treaty, the criminal prosecution of Mr. Ofori-Atta in Ghana for cross-corruption related offense. So I spoke to my lawyers, and it's true. In fact, the preamble to the Adena Mekaima, the judge said that the main thing before his court was immigration, but he went further to comment on it. Some lawyers believe that that was unnecessary. Some lawyers also believe that so far as Ghana wanted to use that immigration riot to cause doubt in the mind of the judge, to give Ken Ofori-Atta a permanent stay, and say that no, we can't give permanent stay, making Ken Ofori-Atta eligible to be extradited. Permanent stay, they are all he has a right to comment on it. So all the lawyers I spoke to and all everybody I've listened to seem to have different opinion on it. In fact, immigration lawyer join us or say the judge has no business commenting on it because the immigration issues are separate from the criminal issues, and the judge doesn't have the jurisdiction to determine what is criminal in Ghana. That's what she also said. So, but for me, I think that it brings into question how public officers will always do whatever to evade accountability. Because, and I've always believed that right after the man was arrested, and those who remember, I'm one of the people, for those who are listening, I'm one of the people who believe that Ken Ofori-Atta has a lot of things to answer. There's no doubt in my mind about it. I've already gone into the, people even think I have a personal vendetta against him. I've already gone to, I don't want to go into the bad. I strongly believe he has questions to answer. But yet, in January, how the man was arrested, what Manasseh told us, detention facility near the court, the history of that detention, and everything proves that the man was not ready to come to Ghana. So that was the day I said that. Maybe you're trying to try an absentia. The judges seem to believe there's no evidence, but he doesn't decide for Ghana. So whatever extradition process you have to go through, let's go through that much and see what it will say. And when you look at the main thing the judge is saying, financial. And I've told you this before, but some of you insulted me. And we are seeing a lot of things happen. So, on it. This is what the judge said. This is the update. Again, I apologize. It was 90 pages. I had to review and get you the relevant portions. As and when they are new developments in the matter, certainly I'll bring it to you on the critical analysis channel. And again, I apologize for my nose. I have a very terrible nose. The weather is dealing with me. It's also been a tough week. Now, Maya and the appear could be today, so you should also expect that from me. There's also an update on some oral cases. I'm also trying to get you the official documentation so that we go through that. I wanted to just summarize everything for you in this 19-minute video. But that's so shame. Now, we are subscriber. More subscriber. No click on the notification. The video be to be enjoy your Sunday. And your mission on count. Bye bye.